I'll just, fellows, I'm only oralizing. I'll tell you a very shocking situation. The governor receives that 100-page order, if I may say so, or the governor does in the order. He doesn't decide a single factual or legal issue. He decides one issue, that he is not bound by the advice of the cabinet, because according to him, the cabinet is the alter ego of the chief minister, even though the chief minister did not come to the meeting at all. Most important, I'm very grateful in discharge of official duty. There is nothing. And these are admitted positions. That's the third ground your lordship must stay this completely laconic, unreasoned order with no application of mind.
Yes, sir.
There are serious constitutional issues. There are direct statutory issues.
Yes.
I'll just itemize them and then we'll deal with one by one, probably with the simpler statutory ones first, and then we'll just itemize also the constitutional ones. Well, as the matter raises far-reaching issues for the reason, number one, I'm only giving the issues, so I should see the. Well, as you have an elected government, the elected government has the mandate of the people. Anybody, I'm not saying these are those people, I'm not saying about them, I'm saying in theory, in jurisprudence, anybody on the street comes with a complaint. That complaint, Malas, is made decades and decades, let us say, assume, after Malas an incident. A, inverted commas, friendly governor gives sanction. Before that friendly governor gives sanction, the government of the state, scrupulously taking away the chief executive of that state against whom the complaint is made. It is not a case where I, Malas, have a cabinet meeting where agenda item 1 I recuse and agenda item 2, 3, 4 I come in again. He doesn't attend the meeting at all. The cabinet collectively takes a decision, and that order is worth seeing. Not in length alone, every possible legal and factual aspect is dealt with in 100 pages. Saying these are the reasons why this complaint is false, frivolous, vexatious, should not sanction, cannot and could not be granted in law by citing case law, etc. This is done after a purported show cause notice is issued by the governor on events ranging from 1992 to 2022. From
1992?
1992 to 2022. I'll just, fellows, I'm only oralizing. I'll tell you a very shocking situation. The governor receives that 100-page order, if I may say so, or a decision of the cabinet. Clearly, he is bound because the cabinet decision binds him and it falls under no part of the accepted category of 163. The governor, in a short 2-page order, which is the impugned document, decides to decide only one point. Does not address any single reason why the sanction ought to be granted on the merits. Not a single word of the 100-page order. Namely, Malas, suppose the cabinet says sanction can't be granted for reason 1 to 50. You can say reason 1 is wrong because of so-and-so, reason 5 is wrong, reason 10, not every ground, but at least most of the grounds. He does not address a single ground. The only ground he addresses is that there is conflict of interest and gives a one para en masse blanket order saying the cabinet is the alter ego of the chief minister who's the accused. Not the accused yet, Malas, but the potential accused. That's all. So, Malas, the cabinet, Malas, on even a doctrine of necessity, cannot act after the chief minister does not come into the meeting on the day at all. There is a single agenda meeting and he's not present at all. He decides that alone. Now, assume you decide that. What you have decided is that the cabinet decision is not binding on me. That's what the governor is deciding, Malas. I hope I'm clear.
Yes.
He is not deciding why.
So is that the observation in the order?
Yes.
Right.
I'm sorry. Back to this case for the last 5 paras. Only the 1 para was off the case.
Yes.
These 5 paras are on the case.
Yes.
Whatever I've said in the last 5 minutes is what the governor does in the order. He doesn't decide a single factual or legal issue. He decides one issue, that he is not bound by the advice of the cabinet, because according to him, the cabinet is the alter ego of the chief minister, even though the chief minister did not come to the meeting at all. He then picks out this complaint out of Malad's at least 15 or 12 pending for some length of time, which he has not decided, not sanctioned, not dealt with, and grants sanction in this one, without a single reason as to why sanction ought to be given, notwithstanding the cogent 20 reasons given by the cabinet decision. So cabinet is not binding, let me assume. Let me assume in favor of the impugned order, if I may call it the impugned order. If the cabinet is not binding, you have to give reasons 1, 2, 3, 4 why the reasons sent by the cabinet are bad. Then we'll see. He doesn't give that. On that short ground, the order is bad. That is one part. The larger issue, of course, is that if you accept this principle, and your Lordship has fortunately in several Supreme Court and Karnataka High Court judgments not accepted it, saying the sanction is a serious matter, it is not casual, it is fully reviewable. But if you accept the principle the way it is activated, anybody here will file a complaint to me. I am the governor, and I have to have only some inclination. I call him a friendly governor. And he will then issue sanction, followed immediately by a clamor for removal and resignation of the chief minister, thereby nullifying the popular mandate. You don't need 356, You don't need any provision of the constitution. You don't need 163 to destabilize governments like this. Is the larger issue. Third issue. So first and main issue is he has not decided on that ground alone. He has not given a single reason why sanction, apart from saying I'm not bound by the cabinet. Second reason is the larger federal issue. The third reasons are narrower, but I'll come to them first when I deal with detail. He grants a 17A purported approval. Purported. Now, Your Lordship, I'll come to them one by one. I'm not.
Yes.
There are at least 2 conditions precedent to a 17A, which are on the face of it missing here. At least 2, if not more. Condition precedent 1 is that it has to be on an application of an investigating agency. Lordship will call him policeman. That is written in the section itself. I don't have to carry scroll to Dhanbad. The second condition is that provided this is a police officer who complains, he then complains in respect of a decision taken or recommendation made by the public servant, namely the chief minister in this case. The chief minister, it is common ground, has taken no decision, made no recommendation, not once. He has never touched the file.
No role? No role of the chief minister?
No role, no file noting, no recommendation, no decision, the matter never came to him. This happened mostly in other governments. 92 to 22. The allegation is that he's a beneficiary. The allegation is not that he's a decision maker. Now, 17A condition on that short second ground, there must be a stay. At the moment of condition precedent, 17A, you pick up and read the text. Has a police officer applied to the governor? My learned friends have not yet donned the police uniform, the complainants here. They are private complainants. Second, can it be a complaint about, show the decision to the court, which is the decision taken by CM which you are assailing? Which is the recommendation made by him? This is that kind of category where Lordship knows 17A was made for when I write on the file some recommendation. And that goes through. There is nothing. That's point number 3, Point number 4 is also the new Sanhita, the section 218 of the Sanhita.
197.
Yes, which is the equivalent of our absolutely equivalent of our 197.
Yes.
Now, here there's another interesting mix-up completely. Also 197, also section 19 of the PC Act. Similar situations. The mix-up is simply this, that you apply in your order 218, but 218 must mandatorily, the Lordship has done enough, 197 cases, involve the nature of the offense and a specific offense. It has to say that this man has committed this offense qua him, namely section XYZ, the ingredients of which offense are these. And in this manner, the ingredient is satisfied.
All in discharge of official duty.
And most important, I'm very grateful, in discharge of official duty. Nothing. And these are admitted positions. That's the third ground your Lordship must stay this completely laconic, unreasoned order with no application of mind. The fourth reason, is natural justice. The show cause comes to me referring, it is preceded by the Advocate General's opinion also. There is one separate small short opinion also by the Advocate General. But forget that. The show cause, which is 26 July 24, comes to me referring to only one of these complainants, Mr. Abraham, who is respondent number 3.
Hmm.
The entire show cause is about one Mr. Abraham, respondent number 3. The final order passed by him after he receives the 100-page order of the cabinet is a 2-page order, final order that I'm not bound. In that, he dismisses the cabinet, grants sanction by adding a paragraph about the other 2 complainants about whom he has never show caused me.